Today I have the privilege of introducing our keynote speaker. He is consumer lawyer Troy Doucette, who will speak to you about federal and Ohio laws that help protect consumers in everyday transactions. Troy owns a 10-lawyer firm in Dublin called Doucette & Associates. The firm focuses on consumer litigation, usually suing banks, mortgage companies, and debt collectors. Troy graduated magna cum laude from Capital University Law School after working professionally in the mortgage industry. He lives in Dublin and has a 12-year-old daughter. He is also engaged to be married this summer. And let me just kind of add to this. Back in March, I had the privilege of joining the firm just part-time, folks. I'm still doing my DMV consulting work. But I can tell you I've had the most fun of all the times that I've been practicing law in 38 years. Because every day I get to go in and interact with some really bright young lawyers who are very motivated at helping people. And I think that's what you're going to hear today from Troy. It really is a firm that has the Rotary four-way test at heart, Paul. So without further ado, Troy Doucette, ladies and gentlemen.
Good afternoon, everybody. Thank you, Mike, for that. And we are certainly love having you around, and a great resource for everybody. And thank you also to Rotary for having me here speaking, and also for all the work that you do. As a consumer lawyer, I do focus quite a bit on asking the question of how can we help people, how can we solve individual problems, and I appreciate that you all do that every day as part of your organization as well. I want to talk about a few things for you. What I did was I looked at what we get the most calls on, what issues we face the most. I understand there's a lot of business folks in the room, business owners. Hopefully, if this doesn't help you with your own world, your own interactions in the communities, maybe how it might help people that reach out to you as a resource in your dealings. So these are six main areas that I'll walk through briefly. I understand I have about a half an hour. Let's focus on the first two a little bit longer than the other ones. As Mike said, I do own a law firm in Dublin. I'm a business partner, Andy Gerling, there. We do focus predominantly on banking-related litigation. I came out of the banking world, mortgage world, and I know where all the bodies are buried, so it's been easy to get into law and do that. We did a lot of foreclosure defense, helping people stay in their homes for a number of years, and probably about half of our business at this point is still mortgage-related litigation. I want to tell you a little story that when we get into the laws around mortgages and your rights. I had a woman call me a few years ago, and she says, Troy, I have this problem. I'm a successful business person. I've got great resources, great income. Over the course of my career, I've moved from home to home, and I've always held on to my homes when I've moved up and rented them out. And I have these small couple investment properties, sources of income. The first home that I lived on 30 years ago, I maintained the same mortgage for 30 years, and I've reached the point in my career or I've reached the time point where it's time for the bank to release the lien, give me my home, and send me back the original note. And I called the bank up a few months ago, and I told them, hey, I want to make sure we coordinate this correctly, that you're sending back the lien, because the 30 years is coming to an end. And the representative on the other side of the phone said to her, well, that's not what our records show. Our records show that you owe another 5 years of payments on this loan. And she said, no, that's not right. I know this loan is 30 years. I'm looking at a copy of the loan, and I have proof of all of my payments from day one. And back in the 80s, I don't know if some of you remember the pass books where you take to the bank and they'd stamp the date and the depositor. She still had these from the 80s demonstrating every single payment, actually surprised me, from day one. And she provided this information to the customer service person at the bank. And bank's person still said, no dice. It doesn't change the fact that our computer says you have 5 years of payments left, and that's how much you're going to have to pay. So she talked to the manager, and then the manager's manager, vice president, ends up in this is a large bank, nationally large bank, ends up in the office of the CEO where they have the special folks there just deal with high-level disputes. And she worked with them for several weeks. Every time the answer was the same. You owe us 5 years more. She'd say, well, why? How do you figure this? We don't know, but that's what the computer says, 5 years, so that's what you have to pay us. So she calls our firm. So at this point, we had an article in Business First, had a little article about our firm. She finds about us. She calls us, and she tells me the story. I said, okay, well, it's time for a lawsuit. That's what we do. Is we sue banks. So we sued this particular bank in federal court. Went on for about a year. And I can distinctly remember during that year, the bank was not able to give us any indication as to why it believed that this client still owed her 5 years. We get in front of a federal judge in a status conference. I can remember his room. He's retired now. And this federal judge looks at the bank's lawyers and says, I don't understand how you all cannot figure out why you believe this person owes you an extra 5 years. And their response was, we're not sure either, but we're working on it. The case settled a couple days after that meeting. That's a lot of what we deal with, believe it or not, is not necessarily 30 years, but issues dealing with mortgages, dealing with banks that have gotten so big that it's sometimes very difficult, challenging for the right hand to talk with the left hand, or for things that are more complex than what you normally see be able to be managed correctly. So the question is what are your rights as a mortgage holder, or what are people's rights as mortgage holders? First is that you do have a right under federal law to ask questions about your mortgages and get answers. And your federal law requires that the bank actually research your particular issue before providing you a response. That's actually new. You weren't allowed to do this, at least there wasn't a federal law allowing people to do this before about 2009. With the crash and the changes in the regulations, RESPA now, Real Estate Settlements Procedures Act, is amended so you can actually ask questions. You also have the ability to request a payoff. Truth in Lending Act allows you to do that. To know who the owner of your loan is, as well as the master servicer. And for a lot of our clients who are facing foreclosure, usually my clients, something happens in their life. They lose a job for a brief period of time, they get injured or ill, and they miss a couple of months of payments, and they want to get back on track. They want to start paying their mortgage again. They want to save their home, but the bank's not willing to deal with them for whatever particular reason. At this point, with the changes in the law, the consumer has the ability to ask the mortgage provider to underwrite them for a modification, which is different than a refinance. It's just change the terms based on getting back on track. If the lender has such a program available, the consumer does have the right to get underwritten for it. And then there's protections, and the protections also allow for clients to hire lawyers to help out, and then the bank has to pay our fees at the end of it. If it is shown that they messed up, that they should have done something that they didn't do, they have to pay our fees, which makes it affordable for our clients. Tangentially, the same kind of issue is debt collection and what happens on that front. I will tell you that just because you don't have any debt does not mean that you can't be harassed by a debt collector. It happens, and I'm going to tell you this story. I do a fair amount of pro bono work through Legal Aid has clinics each week. There's actually a list up. It's too small for anybody to read. I didn't realize it was going to be that small, but around the city. There's one in particular that I go to quite a bit, the Interfaith Legal Clinic over on East Broad Street. And I had a gentleman come in one night who was deaf, completely deaf, so he couldn't verbalize either. And there's a translator that came with him. It was set up through Legal Aid, to come in so he could get his legal question answered. And I took the case. I sat down with him, and the issue was that he received a letter from a debt collector attempting to collect about $1,000 on a debt. He had no idea who this debt collector was, had no idea what this debt was for, had no idea, but it was his name, his information on this letter. He said, I need help with this. I was like, well, let's just give him a call. Let's call the debt collector and see what's going on with this. So we dial up the collector, and I introduce myself, identify myself as his counsel, as his lawyer, and I'll go through the individual proof information. I said, look, this gentleman is deaf. He can't talk to you on the phone, but we have a translator, interpreter here. to assist in the process. We went through, we verified the information, and the debt collector says to me, well, I appreciate you being on the call right now, but I need you to put in writing and fax me over a written authorization that you are his lawyer. And I said, no, that's not the way the law works. Federal law does not require that I put something in writing. You have his information. I've told you I'm his lawyer. You have to talk with me. Well, I hear a little pause, and goes off the call for a little bit, comes back and says, well, okay, but I need him to verbalize, to say out loud that you are his lawyer. I said, hey, I don't think you understand. My client, this gentleman is deaf. He can't do that. Well, then I can't talk to you. I'm sorry, I can't tell you anything about this debt. I can't talk to you. So it's time to get a manager on the phone, and I'm happy to talk with your manager and explain the federal law on this, because you're obligated to talk to me and obligated to answer my questions about it. If you don't, I'm happy to just I tell you what, just give me your address where you want me to send the lawsuit to, and we can either resolve this now or resolve it later. They opted to resolve it later, so we ended up suing them and again resolving that lawsuit within a very short period of time thereafter. But when somebody's going through something like that, my point with this is that you don't actually have to owe a debt in order to run into one of these situations. So it's helpful to know what your rights are under federal law. Here they are. You have the right to have your debt collector contact your lawyer. You don't have to give this in writing. You can verbally say it. I have a lawyer. Go talk to the lawyer. You can request the validation of the debt in writing. If you have no idea what it is, you have the ability to write a letter. They are then obligated to show you what that debt is from. You can ask them the name and the address of them, where they're calling from. If they call you on the phone, they're obligated to provide that, both under federal law and also state law. And you also have the right not to be harassed, threatened, lied to, called before 8 a.m. or after 9 p.m. Not allowed to do that at all. One of the big issues that we see with debt collection across all of our clients that we handle on this front, if there is such a debt, is that the dollar amounts are almost always wrong. The dollar amounts are almost always wrong, and they can very rarely be established or proven. Debts are bought and sold behind the scenes like candy. I mean, debt buyers will buy these old debts, things that are past the statute of limitations, things people have gotten discharged under bankruptcy for pennies on the dollar, just to see what will happen. They'll call surviving spouses or surviving family members and tell them that they're obligated to pay decedent's debts, which is not true, which is false. All those things are run afoul of federal law when they're not true, or when there's harassment or lying available to. In my business, it's unusual, I almost forgot to mention this, but it's rather usual to hear about a debt collector threatening to throw somebody in jail. The police are on the way. You got to pay this debt right now, or the police are going to come to your door. We're going to come break your legs. It's a little bit more rare, but that happens as well. It runs the gambit. What also happens is that unscrupulous debt collectors will require that people Western Union money to them. There might not even be a debt in those kind of instances, but the fear associated with the police or bodily injury, harm, or something happened to the family are so great for people that they'll buy into this and they'll go to Western Union and wire money. And once that happens, anybody can pick it up wherever, and you can't find the debtor. Sometimes it's just a scammer. You also have, finally, people have the right to have a debt collector stop calling them. The consumer has to put that in writing, that you can't do over the phone. If you do in writing, though, the debt collector does have to stop calling. So that's sort of on the debt side. Now, on the consumer transaction side, everybody buys cars. I'm sure everybody in this room has at least one car in their household. One of the most common misconceptions consumers have about car purchases is this 3-day right to cancel. There's no such thing for car transactions. Used cars, new cars, any kind of cars you buy, RVs, boats, there's no there's no state or federal law giving you a 3-day right to cancel a purchase transaction for a car. Some lenders will contract, they'll write in the contract, we agree to, you have a 10-day trial period or 7-day trial period, especially some larger used car businesses. That's fine, they can do that. And if they don't honor it, you can sue them for violating that. But there's no actual code section that provides for a 3-day right to rescind. Instead, one of the biggest rules, biggest laws that consumers have to protect themselves under state law with car purchases, new car purchases, is the lemon law. What is that? It means that if a car is such a big problem within the first year, or 18,000 miles, whichever one comes first, if there's a big issue with a car that is not resolved or poses some kind of great bodily harm or injury to the consumer, you have the right to return the car, get another one, or just get your money back and go someplace else. It's Ohio's lemon law. So the law is first 18,000 miles is when the issue has to develop, and you have to report it to the dealer, the manufacturer, usually it's through the dealer, you call them up. If the same issue, you've got to have 4 repairs for the same issue over the first year, or there's some kind of major issue that's life-threatening or poses a life-threatening harm, or your car is in the shop for aggregate total amount of days as 30 days or more during that year, you add up all the days, 30 days or more, it's considered a lemon. And as I said, you can either return it, get all your money back, plus the interest that you paid, all that, or you can get it for a different car. Life-threatening, what does that mean? How does that look? We had a client that we helped out. She had a car that the airbag light was on, showing that the airbag was not going to deploy in an accident. Somebody was in the passenger side. And she took it back to the dealership. The dealership could not figure out whether or not there's just a glitch and the light just stayed on, or if the airbag really would not deploy in an accident. And that's a major issue that could create physical bodily harm, death, quite frankly. And we were able to successfully designated a lemon and get our money back for that transaction to get another car. Sometimes people just want a different vehicle. Other times they do want to go elsewhere. But that's the big one for new cars. Used cars, the biggest risk you have is if you buy something as is. I don't recommend anybody do that. If you are, take the time to take the car to an independent mechanic, have them take a look at it. It's about $100 to get a full analysis. Because if you buy it as is and you drive off the lot and then it breaks down 20 feet off the lot, it's your problem. It's not the car dealers. We do get calls like that quite a bit. There is a lot of that goes on in certain areas of town where cars are maybe selling for $2,000-3,000 a piece. Somebody might save up, pay cash for it because they can't get the credit, then it breaks down right away. But it is something that we caution people on. If the used car dealer is aware that there's some major issue with the car and doesn't tell you, they can be held responsible. You can sue them and get your money back or get your car. But you have to establish that they knew about that, which is really hard. We have had that happen a couple times, and what we end up doing is we go back to the previous owners of the cars. We ask them, hey, did you tell this person, or did you tell the dealer, the previous person of the dealer? And if we can establish there was knowledge there and then the dealer didn't pass it along, then the dealer can be responsible and under Ohio law. Here's something really interesting a lot of people don't know about either when you go to buy cars. The dealership cannot compare the price to Kelley Blue Book or any other site out there. The dealer cannot say to you, look at what a great deal is this is because you've got this estimate, Kelley Blue Book puts the value at $10,000 and we're selling at $9,000. That's illegal under Ohio law. They are not allowed to do that. They can't post it on the window. Some dealerships will do that, nor can the salesperson bring it out as part of the sales transaction. We had a case where they did that, and they actually printed out the computer printout and had it in the sales material, which enabled us to protect that particular consumer because they weren't able to do it. That kind of technical violation, by the way, usually doesn't come up because a consumer says, hey, they compared the Kelley Blue Book, I want to sue somebody. Instead, what happens is there's a catastrophic failure with the transaction, and the consumer comes to us and says, we had this really bad car that we got into that broke down right off the lot. Is there anything you can do? And that's when we'll look at the whole transaction from beginning to end and pick apart, okay, well, that's in there, so we know that that's a particular violation. That's usually how that comes about. When it comes to car repairs, you do have the right to get a written estimate and also return of parts. Car mechanics actually have to have a notice on the wall that says you have the right to a written estimate. There's a statutory form, the statutory language by statute, what needs to be on this thing. Very few of them ever have it. Very few of them provide the correct disclosure. that can create a situation where the dealership is responsible. Again, nobody calls us because they don't see a disclosure on the wall. Instead, something happens with a repair that caused that. We had one situation where the oil was changed, and the oil change company, didn't screw the cap on, the oil cap on tight enough, and oil leaked out, and she's driving down to Florida, and the car seizes up, and the massive engine failure. And what we'll do is we'll look at the whole transaction, and that action itself is negligence, so they've got to cover that. But we'll tack on what we can to make sure that there's enough protection in there for a consumer, usually just to ensure that the result is where we want it to be. So that's on car purchases. Another thing, we random information, if anybody's part of a gym, 100% of the gyms that we have came in contact with have failed to comply with Ohio law, 100%. We have not seen one of them that actually complies with Ohio law when it comes to the initial contracts. I don't know what it is, but that's what it is. So way this usually happens is that a consumer has an issue that they can't cancel their gym. There's some of the big ones that are known for this. Gyms you pay monthly, and they like that $30 coming in every month, or $50, or however much it is. It's cash flow for them. You add that up over all their clients, and that's some nice cash flow coming in every month. When you want to go to cancel the membership, most of you will, if you do that, you'll find out that you've already prepaid 1 month, and you got to give them 1 month's notice, so it's like you're canceling 3 months out. That's legal, but when it comes into problem, and why people call us, is that the gym membership fails to cancel. They send in the notice, they go to the gym membership, wherever the front desk, they give them the paper, or what they do is they'll mail it in. We had one client who went a couple times to the front desk, gave them the notice a couple times, a couple months, still got the charges on the credit card. Front desk says, well, why don't you mail it down to corporate headquarters? So we did certified mail down there. Still, charges are appearing. That's when somebody gets mad enough where they search on the internet and they find my firm, they give us a call, and that's what we do. That in itself is probably a violation, but what the biggest violation, cleanest cut, is for us to look back to the initial contract. Does the initial contract comply with Ohio law? But like I said, 100% of the time it has not. The initial contract must give the consumer three days right to cancel the transaction. There's statutory language, all that craziness off to the right, that is the actual language from the statute. All that stuff needs to be in there. It needs to be in 10-point bold font. 9-point regular does not count. It has to be at least 10-point bold font. We had one, they almost got it. One company almost got it. They had it all in 10-point bold font except the last 5 words were in regular non-bolded font. And it just is like, oh, come on, guys, but that was a company that, again, wouldn't cancel somebody out, and we hold them to that. They're also obligated to give you 2 copies of that and inform you verbally that you have a 3-day right to cancel. If the gym does not do that, you get up to unlimited amount of time to cancel, get all of your money back, no matter how much you use at the gym, 3 times that in damages, plus all my attorney's fees and costs are covered as well. Provides a very strong incentive to follow this particular law. Also, if you move over 25 miles away from your gym, you can cancel it. If you physically can't do it, you have a doctor's note, you can cancel your gym membership. The Ohio law allows for this. And also, I want to point out that this applies to dance studios, dating sites, Match.com, and dating services, as well as spas, gyms, that kind of thing. If you pay a monthly fee, it's Prepaid Entertainment Contract Act, which will apply, and here's how you're protected as a consumer. All right. I've got 2 other things, and I'm going to be right on time here. Next is credit reporting. Everybody has the ability to get your credit report once per year for free. They don't have to give you your credit scores, but most of the companies out there do have the ability to, most of them allow for that. It's annualcreditreport.com is the website you go to. You get a free copy. You also get a free copy if you're ever denied for credit. You have the right to challenge information that you believe is inaccurate or incorrect. I have one client right now that's fairly successful. He has a home equity line of credit and a mortgage. He has a couple homes, one particular one that we're dealing with. the home equity line of credit has converted into a regular paying amortizing loan. Usually with HELOCs, home equities, you have 10 years of interest only. You can pay, you can take money out, you can pay it off, take money back. It's like a line of credit. And then after 10 years, it turns into a regularly paying, regularly amortized loan for the balance of the term. So what this credit bureau is doing is he's got 2 scores that are each 800, and he has one that's like 690, 95. 94, I think, but he wants to get that next one up. What's the problem with it? Well, the problem is what's causing this one bureau to be lower. The issue is that we found is that this HELOC is being reported as a revolving credit line, like a credit card, rather than as an installment loan. So because of that, and because the balance is relatively high to the original, it shows like he's maxed out on his credit card, basically. And it's a big number, you know, it's relative to credit cards, it's like $70,000, $80,000. So the credit bureaus think that he's maxed out on his credit, and they're dinging his score to probably the tune of about 80, 90 points. So what we've done is we're involved to try to get the credit bureaus to reflect, like the other ones do, that this is actually a real estate loan at this point, regular installment loan. We have the ability to do that. We have the right to challenge that. And if the credit bureau can't validate it with the refurnisher within 30 days, they have to remove it from your credit. In this particular instance, we sent the first letter out, got a response back saying, or the response actually removed a whole nother credit debt that we didn't even ask about and didn't change the one we wanted to, so we're going for round 2. But that's part of the process. And if they don't correct it, if they don't update it correctly, we can, again, hold them accountable. There's a federal law, and it does provide for our fees as well. So we can go and fight this out for consumers to make sure that credit reports are accurate. If you are going to dispute something, I recommend you do the letter first. With a few moments left, I'll tell you about the famous robocalls everybody gets. I got one this morning. Drive me crazy. Doesn't it drive you crazy? I mean, get all those, callers, and then they spoof your numbers. So you'll notice like 614, and then your first 3 numbers of your phone number is the same for the one that's spoofing. It's probably a marketing call. Those are all illegal. They all violate federal law. Telephone Consumer Protection Act, all of them. You cannot call somebody's cell phone with a pre-recorded message, which is when you listen and there's that voice, just doing the sales pitch. It's illegal. The other way that's illegal is you calling your cell phone with an auto dialer. And that's when you pick up and it takes 4 seconds for somebody to come on the line. That's because they have a big machine in the background calling a bunch of numbers. As soon as they get a live person, then they throw it over. There's no requirement for you to be on the do not call list in order for this to violate federal law. There's straight up violation of the TCPA under federal law. Same law applies to junk faxes. If you have a fax machine, you get faxes from people you didn't sign up for, you didn't give them authorization, all those violate federal law as well. What are the damages for you when you get those? It's $500 per phone call, and the judge can treble it up to $1,500. Times it however many calls you've got, it can be very big numbers that you're dealing with. But what happens is, practically, is a lot of these companies are scam companies or they're small operations. So even if I sued them or did a class action against them, I'd probably never collect, which is why we leave that enforcement actions really up to the federal government to step in, FTC and those kind of things to get those guys and hold them accountable. But for you all's edification, it is substantial damages. We had a client once who the debt collector was using an auto dialer to call her, and we were able to prove it in court. And it was 110 calls, and we got a judgment for $55,000 against the debt collector trying to collect $900 debt from our client. So there's a big stick there when it comes to the federal law. Yeah. Well, this one, if they sue us, then we can sue them back, is what we do if we find them, right? So the consumer protection statutes are, the goal is to help people not get taken advantage of. And one of the standards that we use is the least sophisticated consumer standard, is that when you go into court, think of somebody with an 80 IQ. Think of somebody who has a third grade education and somebody out there trying to take advantage of them. That's why these laws exist. That's why we use them. it's ultimately not only to improve the lives of individual people, but hopefully society as well. So you have a magnet on your desk or on your tables. This is our Ask a Lawyer number. I usually take all of the incoming calls. If you have a situation you'd love some perspective on, I'm happy to provide it. But thank you again very much for having me today.
We've got time for questions.
Oh, yeah. I think I have 5 minutes for questions, so if anybody has any questions, happy to. Yes, sir.
Troy, the student loan debt has just eclipsed credit card debt as the #1 non-mortgage debt. From your experiences, do you have any advice on how to help deal with or prevent that from becoming a problem?
It's a very the question is student loan debt, and do I have advice for that not becoming a problem? It is just so big. It's $1.5 trillion in student loan debt right now. It's very, very difficult to avoid student loan debt if you're a student going in. I don't know that there's a solution on an individual scale. You can tell people to work at a job during school, but you know that's not going to cover but a fraction of it. It's just so expensive right now. Also, debts associated with student loans governmental debts are very difficult to get out from underneath. There's no bankruptcy protection for student loan debt, so you can be buried in debt, and there's very little way of getting out. Not only that, but they can come after your Social Security checks. It's one of the few things that they can go after you get disability or retirement. They can also go after tax refunds. It is brutal. I mean, that is brutal. Student loan debt is brutal. It's very challenging. Yes, ma'am.
I don't really have a question, but I want to thank you for your talk today. I think it's great, very informative. But something happened to me a couple of years ago. I'm coming out of the drugstore, and I get a call on my cell phone from a gentleman who said he was with the Federal Drug Administration and that they had confiscated 200 Vicodin pills in Florida with my name on it, and that he was going to issue an arrest for me. And I'm like, I didn't do that. Oh, man, we went round and round, and then I hung up on him. He called me back, and he's like, look, you seem like a really nice lady. If you give me $1,500, I can make this go away. And then I said something that starts with F you.
That's it. Scams are all over the place. My grandmother got a call, and what they do is they'll call you and they'll say, "Grandma," and she'll say, "Troy, is that you?" "Yes, it's Troy." "Oh, okay," and then it proceeds, "I'm in jail and I need your help. Can you Western Union me $1,500? My grandma opted not to wire the money to get me out of jail. But what she did was she called my mother, thankfully, and my mom said, "No, Troy's not in jail. There's nothing wrong with him. Don't wire the money." Scams are all over the place. I could do a whole day's worth on avoiding scams. I'm glad you mentioned that. Bring that up. There's always get a second opinion kind of thing. Yes, sir.
Yeah, I'm just curious. There's a lot of credit card interest rates that certainly we have an opportunity to decline, not sign up for. But I'll throw out a company like Best Buy is tied to Citibank, I believe, at an almost 25% interest rate. And I'm just wondering, to me, I think it draws a lot of people in, and it gets them into a debt situation where all they do is just pay off interest rates. I'm shocked that our government allows that type of a structure. It's almost like legalized loan sharking. And I'm just curious of your opinion and how that's viewed on a larger scale.
Yeah, the usury laws in Ohio, for the practical point, don't really exist. I know the payday lending bill that they're trying to get passed now would curb some of the 500% interest rates that we can see in Ohio, but it's certainly an issue. It's probably a legislative fix to resolve that. Some of the largest corporations out there have a lot of income that they get through interest on credit cards. Some of the profitability is greater than the actual profit from the sale of goods. I know Sears was really big on that. I think JCPenney as well. Yes, sir.
The ROBO-CALLs,
Yeah.
you mentioned, we still get them. Is there any answer to stop them?
No.
What do we do?
I'd love to stop them. I mean, I sue them all day long. You can sue them in small claims court. You can set $6,000 small claims court jurisdictional max. If you get a consumer who get them, not only do you get $1,500, but you can tack it onto a CSPA claim, Ohio's Consumer Protection Statute, which is up to $5,000 non-economic. So you can max out per call, but then you have to go and collect, which is always the trouble.
Sure, but there's all, I mean, you constantly get the calls, so when you
Yeah.
push two to opt out, does that even work?
No, sometimes then they know it's a live person and you'll get more calls from opting out. So it's a pain. I mean, don't have an answer for you now. I'd love to get them to stop. If somebody wanted to hire my firm to actually litigate them all out, I'd be happy to do that. But you got to, again, collect. So,
One last.
yes, sir.
On the robocalls,
Yeah.
I've become very good friends with Tiffany, who wants to sell me, is thanking me for staying at a Marriott resort and all the rest of these places. How do you sue them if you can't find them?
Well, that's two.
How do you know who they are?
So you can, sometimes people go after the actual Marriott, if you know who that is, or the cruise line, wherever they're going. But it is hard to find them. What you do is you get phone number, or what you can do is you can buy something from them, and then you can dispute it with your credit card company that it was fraud, and you might be able to get it reversed, but then you'll have an identity of who they are. Sometimes what I'll do on the phone is I'll just talk to them for half an hour. I figure the more time I can tie them up with talking to me, the less time they're going to have scamming somebody else. So I do too. Thank you.
Thank you, Troy. Thank you very much, Troy. Obviously, robocalls are a big pain for the people in the room. Thanks for everything. See you then.